Hi, y'all, and welcome to tonight's live stream. Well, you can call it karma or revenge, or maybe the best word for it is just old fashioned justice. But whatever you call it, right now, Lori Vallow Daybell is getting a healthy dose of it. Justice is hitting Lori Vallow Daybell like a ton of bricks by way of a legal rule you probably have heard of, the hearsay rule. Now, Lori Vallow Daybell is about to go on trial in Arizona for murdering her husband, Charles Vallow. She wants to defend herself by saying it was all self-defense. Her brother, Alex Cox, killed Charles Vallow because Charles was headed toward Alex with a bat. Two people could have testified on her behalf: Lori's brother, Alex Cox, and her daughter, Tylee Ryan. At the time of what happened to Charles Vallow, both of them, Alex and Tylee, made statements to the police that would have helped Lori. But now both Alex Cox and Tylee Ryan are dead, and Lori can't use their statements, particularly Tylee's, to support her case. So let's talk about why. First, I want to give kind of an overview of here's what happened. On July 11th, 2019, Charles Vallow came over to his wife. They had been separated, but his wife Lori's house. It was prearranged. He was going to pick up their son, age 7, JJ, and take him to school. But while Charles was there, he got into a fight with Lori. Alex Cox, Lori's brother, had come to visit the night before. They were supposed to have a, quote, fun day that day, and he began defending his sister. So the fight woke up Lori's daughter, Tylee, age 16. Tylee was from a prior marriage of Lori's. Tylee came out of her room not quite sure what was happening, but toting a bat just in case. So Charles Vallow, Lori's husband, took the bat away, and Tylee went outside with her brother JJ to wait in the car. Alex Cox says Charles Vallow threatened him with that bat. And so Alex Cox went into his bedroom, retrieved a gun, and shot Charles dead. Alex called 911 and told the officers he had been scared for his life, and he shot Charles in self-defense. Now, at the time police arrived, Lori wasn't there, Tylee wasn't there, JJ wasn't there. They had all gone to take JJ to school. Now, police, Alex said he had been scared for his life. He shot in self-defense, and police bought it at first. Then, when someone shot at another relative of Lori's, and then when both Tylee and her brother wound up missing, everybody began to rethink. Lori Vallow is now about to go on trial for conspiring with Alex Cox, her brother, to murder Charles Vallow. And what she wants to be able to show is that Charles Vallow was threatening Alex Cox. Alex shot him in self-defense. But it turns out that the best witnesses are not able to help her because they're dead. Now, Tylee told the police, and you're going to watch some clips from that in just a minute, that she was afraid of how wild Charles was acting that morning. So she brought a bat out to protect her mother, that Charles took it from her, and so forth. There were tons of questions about whether her story made sense and about whether Tylee would voluntarily tell the police that, or kind of what was going on behind the scenes. But as it turns out, of course, Charles was just the first of a string of murders across 2 states. Tylee was last seen just 2 months later on September 8th, 2019. And then 2 weeks after that, Lori's son JJ was seen for the last time. 9 months later, police would find Tylee's body buried in the pet cemetery of the backyard behind the house of Lori's new husband, Chad Daybell. JJ's body was nearby, also buried in Chad's backyard. Lori and Chad had both been convicted of murdering Tylee, and they told their friends that Tylee had become possessed by an evil spirit, that she had become a zombie, not even human. They also have been convicted of murdering JJ, who was just 7 at the time. He also, as I said, was found in the yard. Chad Daybell's wife, Tammy, died just a few weeks later, conveniently leaving Chad single so he could marry Lori 2 weeks after Tammy died. So Chad and Lori were convicted of the murders of JJ and Tylee and Tammy Daybell, Chad's wife. So it's a twisted tale, none of it being any good for Tylee. But after All these years, Tylee is finally getting a moment, just a moment of sweet revenge, and it's all part of the law, the hearsay rule to be precise. And I'm going to go through it and talk about why this is happening and how it's happening. So everybody admits Charles Vallow was shot. The question is not, was he shot? Did he die? The question in this case is, was it murder or was it self-defense? And in about a month, an Arizona jury is going to answer that question. 5 people were present that morning when Charles was shot, and 4 of them are dead. Just let that sink in for a minute. 5 people were present. 4 of them are dead. Only Lori is alive. And the jury is going to have to ask the question, just how trustworthy is what she says? A jury will soon let us know what they think about that. Charles, of course, was the person killed, so he's not around to testify about this. Tylee was killed by her own mother 2 months after this incident, so she can't testify for Lori. JJ was only 7 and he was autistic, so he probably couldn't have testified anyway. But in addition to that, his mother has now been convicted of murdering him. And then finally, Lori's brother, Alex, he was not killed in anything related to this incident, but he died about 7 months later in December of 2019. And authorities concluded he just died of natural causes. But there are a lot of people who find it really too coincidental, given just the trail of bizarre and odd things that led up to his death and some of the strange things he wrote and said. So now, just when Lori would want Alex and Tylee around to testify on her behalf, to say that Charles Vallow was acting crazy, that they were all acting in self-defense, the problem is Tylee and Alex are not here to support her claims. Alex's death, in fact, has doubly negative consequences for her. We'll talk about that. So special shout out to the first 5 in the chat tonight. Camilla Juliana Gonzalez, Angel LaFawn, Michelle B., Lorna Lee, and Oklahoma Gigi. Special shout out and glad to have all of you here tonight. Also, I put a post on YouTube. If you would, what I was saying is my dad is turning 90 in just a couple of weeks here. I am trying to talk him into doing an interview because I think it would be fantastic. We could ask him all kinds of questions about what it's like to live to 90, what has changed, what's different, what's his advice for all of us. And so I'm trying to get him to agree to that. He has not agreed to that. I tell y'all a lot of times how I'm pretty shy and introverted. Let me tell you what, my dad makes me look very, very extroverted. So anyway, if you would go over to that video and hit the thumbs up on it, it's not even a video, it's just a post. But if you'd hit the thumbs up on it, I would appreciate it. I'm trying to talk him into it. So help me out by letting him know people would really like to hear that. So let's start with what Tylee said happened. This is what Tylee told police the day that Charles Vallow was killed. And it would have been, for the most part, helpful to Lori. But it's not going to be admissible at trial. I will explain why, but first let's see what she said.
I woke up probably around 7:50, I want to say, because I heard yelling from like right outside my door. I don't even know what I heard, but I immediately like jumped up, and I have a baseball bat because when I was living at my uncle's by myself, I just wanted something to like feel safer, and I'm not old enough to get like pepper spray or anything, so I was like, okay, I'll get a baseball bat. So I have that. I immediately just jumped up and I grabbed my baseball bat and I opened the door, and it was my stepdad, you know, outside the doorway, and then my uncle kind of in the doorway, and then I could hear my mom behind him, and he was just screaming at both of them, like, I don't even know what he was saying, because honestly I was just too like wired, I guess. So I told him to take a few steps back. I was like, you're too close, you need to step back. And he was like, don't tell me what to do. And
so let me stop it there for just a minute. This is the part where Lori says this was a statement against interest. We'll talk about what that means legally, but she's trying to make an argument that what Tylee says ought to be allowed into evidence because Tylee is making a statement against interest. She's saying that Charles told her she might go to jail. The idea behind a statement of interest is that a person wouldn't say that unless it was true, because it's not in their best interest to say that. It's a statement that would be a problem for them. I also saw Amanda asking about how exactly do you get to that chat, to that comment I mentioned where I want to interview my dad. How do you get to that? It's on YouTube. You sometimes see posts which are just writing as opposed to video. That's what it looks like. If you click on Lawyer Leave the Channel, you can get there. But if you would, hang on for just a minute. Let's watch this video, finish this video first, and then go like it. I'll remind you again at the end, so don't worry about that. All right, so this is the part Lori thinks might make this admissible. We'll talk about why it doesn't.
He was getting really close to my mom, so I kind of stuck it out like between them. And they were both just yelling, and he was like, if you hit me with that baseball bat, you're going to go to jail. And I just kind of stood there with the baseball bat, and I didn't really say anything.
When you said they were yelling, who was yelling?
It was mostly my stepdad.
Okay.
Well, he was really the only one, like, yelling.
Mm-hmm.
My mom was kind of, like, responding,
Mm-hmm.
but I honestly couldn't tell you what they were saying. It was kind of just, like, all jumbled up in my head. And so I just kind of stuck the baseball bat out there, and then he just grabbed it and tried to take it. So I held on to the end, and then eventually I fell, and he kind of took it into his hands like he was going to do something with it. And that's when...
So when you fell, he ended up with the bat?
Yeah.
Okay.
And so I fell to the ground, and then my uncle kind of, like, I saw him take a step back, so my uncle, I think, grabbed him and kind of took him back so he couldn't, like, do anything.
You saw your stepdad, like, take a step back?
Take a step back, because he was really close to begin with, and then and so my mom said to go with JJ, and so I ran out the door, and I heard a noise, which I know what it was now, but it sounded like, because I knew that the baseball bat was in there, it sounded like someone, like, took it and hit it really hard against the floor.
Like, is there a reason you put the bat up?
Let me stop it for just a second. Here's the thing. Charles, if you heard what she said there, her stepdad, Charles Vallow, told her she would go to jail if she hit him. But Tylee never did that. So there was nothing that would cause Tylee to fear she was going to go to jail if she confessed that she was holding a bat and someone said, if you do something, which she never did, then you would get in trouble with the police. So here's a similar comment. You can hear it again in this next clip.
Yeah, he was walking towards my mom, and I just didn't want him to do anything, so I kind of just stuck out the bat. Like, my mom was right beside me, and he was right there, so it wasn't, like, between them.
Okay.
It was kind of just, like, I just stuck it out to be, like, keep your distance, kind of.
When you say you didn't want him to do anything...
It's, for the most part, been pretty, like, mundane, but there have been a few, like, violent times with him when I was really scared that he was gonna hit me or hit my mom, like, just because everything was kind of crazy. Me and him have always kind of not gotten along, like, just since I was little.
So that happened, and he grabbed the bat from you. So kind of tell me that again real quick.
So I kind of stuck it out, and this is when he was like, if you hit me with that baseball bat, you're going to jail, and I didn't say anything because I'm like, okay.
So clearly you can see that it's not a statement against interest, because someone's saying, if I did something I never did, then I would get in trouble. So it's not anything directly suggesting that there's any kind of possible trouble that Tylee could have gotten into. So she's not admitting anything that would fit under that role.
So when you came out of your room and he took the bat from you and...
Yeah, so my stepdad was like, he was like, I don't even know how to explain it. He honestly just looked like kind of a crazy person.
Okay.
Like, screaming, and like his face was beet red. He just looked like really mad. I remember when he took the bat from me, I saw his face for like a split second, and I honestly, like, it didn't even look like him. He just looked like pure, like, rage. Like he was just seeing red. So I haven't really seen him, like, all the way like that before. That's, like, the craziest I've ever seen him. And then my uncle was kind of calm. Like, not super calm, obviously. It was, like, a stressful situation. But he's, like, I don't know. He was kind of just standing there in the doorway, kind of just being protective of my mom.
All right, so let's pull that out. So you can see how helpful that testimony would be to Lori if she could use it. because Tylee is talking about how enraged Charles was, how she saw his face, how red he was, how upset he was, how he was holding the bat because he took it from her. But since Lori murdered Tylee, and that's what a jury has found, that testimony can't be used. And that is Tylee's revenge. That would have been helpful for her, but now it can't be used. It can't be used by Lori. And here's why. Let's go into some explanation of that. It's all due to hearsay, because all of the people who could have helped her now are dead, and those statements that they made are hearsay. So what is hearsay, and why is this not admissible? So the hearsay in sort of legal terms, let me give you one sentence and then we'll unpack it. It's a statement of an out-of-court declarant offered for the truth of the matter asserted. So breaking that down, it means it's something somebody said or that they wrote down, and that person is not here to talk about it. They are an out-of-court declarant. They're not here. And it could be because they are deceased, but it could also be because they're on a trip or they couldn't be found, whatever. And then third part is that the reason you want to present this evidence, this statement, is to prove that what it says is true. So if it's to prove something else, then it's okay. But if it's to prove that what they said was true, then it's not allowed. That's what hearsay is in general. But it's not hearsay if you're not offering it to prove the thing is true. So if it's for some other reason. And even if it is hearsay, there are 25 exceptions under Arizona law. So the court has to ask the question, do any of these apply? And at the hearing, the pretrial hearing yesterday in this case, the judge went through a discussion of what exactly are the reasons, Lori Vallow, that you believe these should be admitted, and why does the state think they shouldn't be? And we're also getting a kind of quick lesson on why you shouldn't represent yourself. There is much more of that to come as the case moves into trial. Lori Vallow Daybell has decided to represent herself. She is not going to use an attorney. She does have advisory counsel sitting right beside her there at the table, but they are instructed that they are to let her present and argue the case. She's in charge. So what initially happens is that Lori gives, throughout this, you'll see Lori will tell the judge, the reason you should let this in is 803, and she'll 803, 4 or whatever. And but she doesn't give him any explanation of why that is. I think probably because she's not really sure exactly why. Somebody's written down for her, the reason this comes in is 803. And so she says that, but she doesn't really know how to explain it to the judge. And she never gives him specifics. And you'll hear him say throughout this, well, like, what statement are you talking about? And the way this ought to happen, the way it should be going forward, is that the attorney would be saying, here are the statements made by this person, in this case, Alex Cox. Alex Cox said blah, blah, and blah. Here's why you should let that in, judge. And instead, Lori just says, everything he said to the police should be admitted under, and she'll give a number. And that's really all the judge gets. And he's trying to unpack this and figure it out. One of the significant problems when a person represents themselves is that the judge is put in the very awkward spot of not representing that person, yet trying to make sure that the record is protected and that there aren't mistakes made that then will get the case reversed, so it has to be retried. So in this case, motions in limine have been filed. Those are advanced motions. And the bottom line of what they're about is Lori Vallow Daybell wants these statements of the police to come in. The state either doesn't want her to use them or doesn't want her to use some of them. And the judge is going to say in general, look, these are hearsay, and they're statements made to the police by Tylee and by Alex Cox, and they're not here to testify. They're not here. So normally these statements wouldn't come in, and the judge is trying to figure out, okay, is there an exception?
The defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what?
So that I think she thinks that it's only going to be hearsay if the person tells the entire story. And since each person tells a different facet, then it doesn't count as hearsay. That isn't what the rule is about. So keep listening.
Said was true.
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So yes, I think they're for that purpose.
So the problem with this argument is that the way the police treated this event, and they did initially assume it was self-defense because they didn't charge anybody right off the bat, but whether it was actually self-defense is the point. The point is not what the police initially thought. She could probably ask the police when they get on the stand, isn't it true that you didn't charge anybody for X number of years? Isn't it true that you never charged Alex Cox? Isn't it true? You know, she could ask those questions, but the statements made by Alex Cox and their effect on the police, that's not the primary issue. The effect on the police isn't the primary point in this case. What the jury is going to be trying to figure out is, was it self-defense? They're looking at what happened to Charles Vallow, not what the police thought about what happened. It may be, part of that may come in, but not the entire statement of Alex Cox for this reason. So Lori is also going to argue, okay, if this is hearsay, it ought to fit under one of the exceptions. And the exceptions are legal rules that are reasons that even if it's hearsay, they might come in. And let me go ahead and add to the stage some of these. Oh, I have to remove this first. Okay. That's a new rule. Okay. All right. So let's take a look. This is Arizona Rule of Evidence 803. This is not legal advice, but I pulled this up today, and I do not practice in Arizona. So what she is going to argue is the 4 you're seeing there. We're going to talk about the first one first. Present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. Now, what's that talking about? You'll hear the judge talk a little bit about it in just a minute, but the idea is while something is going on, the person is saying, this is what I'm seeing. It might apply to a 911 call. Why he's coming toward me now, carrying name some murder weapon and coming toward me now. And the present sense impression might be permitted. It would be describing or explaining what's happening either right then or, quote, you'll see it right there, immediately after the person perceived it. That immediately after is going to be important. All right, let's go back into the hearing.
I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think apply to?
Specifically his statements made on body cam to police in the driveway, specifically his...
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 803.1, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying something
prior.
that he's, okay,
Correct,
so it's
prior.
not a present sense impression.
Okay.
So the judge has shot down this one because he's saying it wasn't happening the statement wasn't happening while the event was happening. Now, the rule actually does say or immediately thereafter, but the judge is saying it's too much of a time difference. She could have argued here at this point, well, this is close enough to immediately after when it comes to an enormous event like murder or enormous event like killing someone, then immediately after is a pretty long period of time and certainly 20 minutes. She might have made that, but I think she was right to move on to the next exception because it's actually probably a better fit for what this is, but you will see what the judge thinks of it.
What else?
Then I think it falls under 803.2, excited utterance.
And let me go ahead and add this. Oh, wait, I have to remove that and add this to the stage. Okay, so let's look at excited utterance. A statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. So it would be like, he's got a gun, things like that, things that are relating to a startling event, something that surprised you, something very important, and you were under the stress at the moment you said that. Again, it's possible she could argue the stress from an event this big certainly lasts 20 minutes or so until the police got there. Now, there's going to be an argument at trial that was a lot longer than 20 minutes. And in fact, that Lori Vallow and Alex Cox intentionally delayed getting there, but that'll come later at trial. For purposes of what we're talking about today, let's just stick with this.
He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds. To other people, it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know.
It's actually kind of funny that he's asking that because that's going to be something the prosecution goes after very hard at trial is how long was it before they called the police? But the judge does seem to be kind of moving back to that present sense impression because he's asking about those words immediately after. And that's not actually under the excited utterance rule. It's while under the stress or excitement. So it's similar but she doesn't really make the argument. She never really goes to the argument about, and she probably should have been ready with some of the things like how long it was, at least from her standpoint. She may be holding back because she knows it's going to be an issue at trial. So this is kind of one of the things that makes it so difficult for a judge is the judge is having to worry about, okay, what should the arguments be? Am I missing something because I'm not understanding this point she's trying to make, in which case maybe the case gets reversed on appeal, and I don't want that. So the judge is trying to figure all this out, and he's trying to be very careful not to sort of ride roughshod over her rights, but to make sure that he lets her represent herself and then stops there. So we'll keep hearing what he says.
What time they arrived.
So you're asserting excited utterance. Some of these statements come in. What else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Okay, so let's remove that and add this back to the stage. So let's look at our next one. Number 3, then existing mental, emotional, or physical condition. That's what she's talking about now. A statement of the declarant's then existing state of mind, meaning something Alex Cox said, and it tells us what his state of mind was, such as motive, intent, or plan, or emotional, sensory, or physical condition, such as mental feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the validity or terms of the declarant's will. Ignore that. This is not about a will. So it's what they're talking about here is whether or not Alex Cox is making a statement about his existing state of mind. And we're going to get to Tylee in just a minute. Right now, we're kind of going through what the rules are as they got discussed with Alex Cox, and then we'll talk about Tylee. But what was does this statement show us what Alex Cox's state of mind was? And is that important? Is that important? And that's part of what the issue is. To the extent Alex is commenting on his state of mind at the time he shot Charles, it would be relevant, but it would never apply to Tylee, because if Tylee testified maybe that she had brought the bat out because she was afraid of Charles Vallow, that might go to her state of mind. If the question was, why did she bring it out? She was afraid. But in this particular case, nobody was hit by the bat. The bat had nothing to do with anything except until Charles took it away. And then whether or not Charles threatened anybody. Now that's the issue. So the state of mind of Tylee isn't really relevant. This isn't important, and it doesn't have any place in this particular case. So the next argument she makes is just kind of nonsense. I want you to look at what the rule is. Recorded recollection. A record that, and she's going to say, see, there's an A, B, and C here. She's going to say, well, I didn't know. I know the state says A is wrong, but B and C, there's an and between them, and I thought it was good enough. I could either do A or B and C worked. But when it has and after B, it means all three of these things have to be true. So this is recorded recollection, a record that is on a matter the witness once knew about, but now cannot recall well enough to testify fully and accurately. This is really designed for people who wrote something down at the time. Maybe they wrote a diary or a report or something like that, and they can't remember. It's been a long time, but they know they wrote it down, and whatever they wrote down at the time would be closer. And so they would maybe be able to read this as an exception to the hearsay rule. The next is made or adopted by the witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So in this particular case, the problem is this isn't really the right situation. This is really designed for witnesses who come to trial and then they just can't remember, not for witnesses who aren't present, for witnesses who are dead, who made statements beforehand. It's supposed to just be something that would remind them of what they said. They would use that to recall what had been said. It's not designed to let somebody like Tylee testify after her death based on what she said at the time. And why does it matter so much? Let me make sure I mention that. Why does it matter so much that something is hearsay? The problem with it is the person isn't there to be cross-examined. So when the person says they aren't present, and normally you would have one side be able to ask questions. So if Tylee came in and said, I came out with the bat and Charles grabbed it, then the state could say, well, isn't it true that you were turned the other way and you didn't know whether he grabbed it? They could figure out all these things that they could ask about, but Tylee isn't there. And maybe they would even ask questions like, did your mother tell you you had to say this? Who knows what they would ask, but they will never get the chance, because all that happened was Tylee came in, made a statement. No one cross-examined her. The state never had the chance to cross-examine her. And so that doesn't count. The whole point of the cross-examination is to make sure that the jury is only getting true and accurate information. If they're getting only part of the information, if no one ever tests it, if they never figure out where the flaws in it are, then they aren't able to really truly get to the truth when the jury makes its decision. That's our thinking behind hearsay. We want the party there, not the party, the witness, so that the person can be asked all of the questions for both sides. So the recorded recollection is supposed to be a way of getting around hearsay, but the person is present. They're right there, and you can ask them about it. It's not someone who isn't even present. So let me add to the stage.
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B5B, the recorded recollection of his police interview and the body cam footage, applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements. Does the state?
So just as what is happening here is the court is in the super awkward position of having to try to make her case for her and to make sure it's at least all on the record, because he doesn't want to be reversed. But this isn't really exactly correct. She isn't really making the argument the way it probably ought to be made. So he's going to ask the state now, are you going to use this? Because maybe if the state is going to use part of it, maybe she has an argument that the whole statement ought to come in as a matter of completeness. In other words, because the state wants to use this part, it's not really fair to only use little excerpts. So if Lori wants to put in the whole statement, she's entitled to do that. So he's going to try to find out, is this something that, can I maybe move out of this entirely because the state is going to put in part of it? And he's going to ask some questions about that.
Intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning.
8:30 a.m.
Is
roughly.
when the 911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station, and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right.
And let's talk about this, because this is so bad for Lori, because what this means is that the state can use the statements of Alex Cox as a co-conspirator. That's the rule. We can look at it right here. And opposing, these are not hearsay. This goes under 801, meaning it never is hearsay in the first place. An opposing party statement, the statement is offered against, and I put that in pink so you notice it, against an opposing party. So in other words, it's not like Lori can say, hey, this is a statement made by my co-conspirator, so I get to use it. This is only for the state. The state is saying Alex and Lori conspired to murder Charles Vallow. And so an opposing party statement is offered against an opposing party. The statement is offered against. And go down to E, what, not just and, these are different, was made by the party's co-conspirator during and in furtherance of the conspiracy. This is tiny. So what they're saying is the two of them together worked together and they murdered Charles Vallow. And so whatever Alex said can be used against Lori in the case against her. But Lori can't use it affirmatively. She can't say, well, my co-conspirator said I'm completely innocent. He said I had nothing to do with it. Here's the evidence. She can't do that. The rule only works in one direction. The rule works in the direction of the state can use the statements of Alex Cox against Lori because they are claiming he is a co-conspirator. So this is a super serious problem for Lori Vallow Daybell. The state can bring in statements and she can't. And that's why I think the judge was exploring it. Maybe if they put in part, she could put in the rest as just a matter of completeness and the rule of completeness. But at this point, she doesn't get to use these statements in the same way that the state does. Now, when it comes to Tylee, the state is not offering her statements at all, and Lori can't.
Is the state intending on introducing any statements of Tylee?
No, Your Honor. Tylee made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station again after 10 in the morning.
So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, with the same thing, her state of mind, then being scared.
So Tylee, of course, first indicated that that she was bringing this bat out because she was afraid of Charles Vallow. So I think Lori is referring to the idea that her state of mind in bringing the bat out was what could actually be important in the case. But again, as I mentioned earlier, her bringing the bat out is not the issue, because that had no play other than it got the bat present. So it's not as if her state of mind in bringing that out was relevant to the case. It wasn't important yet.
And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview, saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's.
But everyone has said that Tylee got the baseball bat. Alex, Tylee, Lori. We don't know what Charles said, obviously. If Tylee got the bat, the implication is she had a reason. And the reason was that Charles was being aggressive. He was scaring her. The problem, of course, is that 3 of the 4 can't testify to that. Only Lori. The question, is the jury going to believe Lori by herself? That's going to be the question. Now, Alex Cox might have been suspect, but Tylee would have been very credible. She would have been a big help in this regard to say that she was afraid of Charles Vallow, that his voice was frightening her. So, but the judge quickly ruled on this.
Police interview.
All right, anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding. Reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
I mean, can you just imagine how insanely unfair it would be to allow somebody to literally kill the witness, and that way you get their first statement in without worrying that maybe the cross-examination would undermine their testimony. Maybe they would testify differently. So just mental note to self, right? Never kill the best witness in your favor. So the judge now rules against Lori, leaving a little bit of a door open. We'll talk about that.
The court is, on a preliminary basis, precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced.
All right. So what's the upshot? Tylee could have testified to exactly what Lori wants to defend herself with, that Tylee brought the bat out, that she was afraid, that Charles was crazy, that he was enraged, that everyone was right to be scared of him, that he did seem really scary. But she's not going to be able to testify to that because Lori murdered her. And many people have wondered if she was even coerced into saying the things that she said in the first place. But Regardless, it cannot help Lori now. It's unclear how much Lori will get in and what Alex Cox said. If anything, it will be what came from the 911 call when he's sitting out in the driveway talking to the police on body cam. It's pretty brief, as opposed to the lengthier interview that they did at the police station. And it probably will be pretty important for the state to at least put in that initial body cam, because some of the things Alex Cox says contradict what Lori Vallow Daybell will tell them later. At the time she was Lori Vallow, what she will tell them later at the police station. And they're going to want to put that in to undermine her credibility. I think there's no possibility that she moves forward in the case without testifying, especially since she's representing herself. It just does seem to make sense. So I will answer a few questions now. I want to say a special shout out while we're waiting for, please be sure to put question marks at the beginning of your question so I can spot it in the chat. That'll make it a lot easier. I want to say a special shout out while I'm waiting for people to get their questions in to our mods. Marlon, Mama Pinks, Denisepelton do such a good job. I'm very appreciative to all three of them. And don't forget, I told you I would remind you toward the end to hit the like button on that post I did about my dad's 90th birthday. So we'll get to that in just a minute. Don't leave. We're still answering questions. All right. Michael Lalonde asking, could this spell double trouble for Lori Vallow Daybell? I think it's a real problem. I think it's a real problem because she doesn't have people to support her. And you could call it, like I said, you could call it karma, you could call it justice, but I think that she's in a world of trouble because of the situation. All right, so looking for question marks at the beginning. Marjorie asking me, how would you say Lori Vallow Daybell is doing so far representing herself? And is she bound by the same oath as bar members about truthfulness, etc.? So Marjorie, I think she's doing okay, but the problem is I think she doesn't really understand the underpinning. So when she goes to make an argument to the court, it's not that she doesn't use the right words, but as soon as he asks her a question, she can't answer that question because she didn't understand what she just said. She read the words. It was an 803 present sense. She's like, okay, well, how is that present sense? And she doesn't know. And I think that's creating problems, as you would expect it would. That's exactly what you would anticipate. And people have warned her about that, but she wanted to represent herself anyway. So that's my perspective on how she's doing. It's going to be awkward. The prosecutor has asked for extra time on the trial, saying this cross-examination is probably going to be really long, Judge. So went from asking for 2 to 3 weeks to 6. The judge said, oh, that's too long. Not going to be that long. Nonetheless, that gives you an idea that everybody is trying to restructure the whole trial around the fact that Lori Vallow Daybell is now going to represent herself. It's creating a significant issue. As far as she's bound by she will probably be sworn prior to the time that she takes testimony or that offers any testimony. She would be sworn under oath for that. She would be bound by, she's not exactly bound by the same oath. She's not a lawyer, so that's not exactly the right way to put it. But she does have responsibilities to the court because of her role in representing herself. So that, I guess, that's the best I can answer you, Marjorie, on that. Okay, so Beverly, who will supply and pay for Lori's court clothing? I don't know. It depends on the jurisdiction as to how they do that. Sometimes they have just a closet of clothes. Sometimes, the lawyer will bring them in. I really don't know how they have it arranged here. She was asking questions at the hearing about exactly how it would all work with her ankle bracelet, and she apparently has a stun vest on underneath the clothing. So that all of that, she was wanting to know, will I go to the podium? How will I do it? And the judge told her that she could go to the podium, but she would need to pretty much stay at the podium, and then the exhibits would be within reach of her. If she needs to hand an exhibit to a witness, then her counsel, the advisory counsel, not representing her, but advising her, will take the document to the witness. So that's what the judge explained. All right. Sky Goddess, will she be allowed to wear her own clothes? I would think she'll be allowed to wear street clothes, but she will have to apparently keep on that stun vest and the ankle bracelet, because there was no discussion about dropping those. The only question was what she just wanted to know, what are the rules around how I'm going to be doing? And that's what they discussed. Mystic Waves, I'm curious about what the attorney sitting next to her is thinking. I was thinking the same thing. I don't think I could do it. I would be writing down everything, which, she's correct in not doing that, but it would be so hard. I was wondering the same thing. Mystery Singer, why is she representing herself? Just add some more question marks after the why, Mystery Singer. There's not really a legally good explanation for that. There may be psychologically interesting answers to that, but not legally good ones. Amanda asking me, do you think she'll be able to keep her cool when questioning witnesses, especially ones like Kay Wood? I think from what we've seen, I think the answer is definitely yes. I think she feels, the way she projects, and she did in the interview with Keith Morrison, she projects as super confident and is feeling very superior to everyone. So she may feel like, well, this person is lying to me, but I don't get the impression she'll be angry. She'll just be like, wow, that pitiful person who is lying to me. I don't get the impression she'll lose her cool, but we will find out, because this is going to be a wild trial, incredibly different. I've heard that she was upset with her lawyers in Idaho who handled her trial for her, and I did feel like they were not active or aware enough. So I have a feeling she wants to do this very differently. So I think she will be far more active than they were. So we will find out what that translates into in terms of a trial. Teresa Strong, why on earth, again, would she want to represent herself? I really think it has to be two things. The upset with the attorneys and the way it was handled in Idaho, and the thought that was truly terrible. I could do better than that. That has to be one. And the other is, I think, sort of an arrogance that she is fully capable of doing this, that she's better able to handle it than the people around her. I think the lawyers who represented her in Idaho were very, very inactive. And so I don't blame her for wanting something different, but I think the decision to go so far as to represent herself is a mistake. I think she also was upset because the attorneys representing her in Arizona were calling for an examination of her psychiatrically about whether or not she would be able to continue with trial. And I think she did not agree with that. Well, I know she didn't. She, in fact, got counsel to represent her against them, saying that, in fact, she didn't need that she was completely mentally sound. And testing, that's exactly what they determined. All right. Why is Lori allowed to wear an off-the-shoulder prison uniform? I did notice that. I really think the thing is, I believe she was handcuffed at the time, and I think it was just really huge, and it just slid off. I don't put any. I don't put anything around that in terms of intent at this point. If more of that happened at trial, that would be another matter. But for now, I'm giving her full credit. It's just believing she just had too big a uniform. It slipped off and she wasn't able to really fix that. So that's my opinion currently. Para Women Radio, will I be in court? I'm going to be watching. Well, that is such a good question. The answer is no, I'm not going to be in court, but I may watch it on the YouTube channel. It's going to be broadcast. It's going to be broadcast by a number of outlets. Court TV is going to be responsible for doing the actual video, capturing that and feeding it out. So I can watch that. We had discussion on last week about whether or not people were more interested in Karen Reed or were they more interested in Lori Vallow Daybell. Please put your thought in the chat or in the comments. I would be very interested in knowing what you think. They happen at exactly the same time. I think it's going to be pretty difficult to cover both. So I'm very curious about what people think. We did a poll on that, but I'd be interested because this is now I'm covering the Lori Vallow Daybell case, and we covered the first trial as well as Chad's trial. So I would be very interested to know in this group, what is your vote? What do you think about that? So let me know, put that in there. Nani Ann, will they allow the jury to know that the other three are not here anymore? I believe it would have to come out that Alex Cox is deceased. Otherwise, the question would be, well, where is he? He's supposedly the guy who shot Charles Vallow. Why didn't he show up? I think the jury would have natural questions around that. I don't know that they will know what happened to Tylee. If they don't already know that, I'm not sure it would be apparent. They may be told that the daughter came out carrying a bat and then he took it away, threatened. I mean, that tale may get told, but I'm not sure it's going to happen and I think it will get told by if they use the body cam from Alex Cox sitting out there on the curb. But I don't think that necessarily means that they're going to hear about Tylee, and I don't think JJ is really going to be relevant at all. Not that he isn't personally relevant, but in terms of the ability to present what happened to him in this trial, I think probably the judge will keep that out. That's my guess. Beverly Parker, will the jury know she's serving life without parole for killing her kids? I don't think so. I don't think they will be told that. But they are going to be asked about specifically Lori Vallow Daybell. They're sending out a questionnaire to the first 200 by email in about a week and a half. And then they'll have a few days to answer that before they come in for jury selection. Then they're going to bring in another round of 200 and another round of 100. And in the questionnaire, they're going to specifically state Lori Vallow Daybell's name. The judge said, I don't normally do that. I don't normally want to put the defendant's name out there. If anything, I would think everybody would run out and start Googling and researching, which is really not what should be happening. But the judge said, I think in this case, I just have to, because we've got to know what they know about the case, how much they know and how much of a problem it's going to be. Lori Vallow Daybell pointed out that there were, I believe she said 1,900 brought in for her trial in Idaho. So actually 500 is pretty small. It is smaller than a lot of the trials we've seen and covered here on the channel. This is a pretty significant trial. It isn't probably as significant as the murder of the children. That trial was enormous and for obvious reasons, but it is still a very heavily covered trial. So I don't know. I hope they have enough. I hope 500 proves to be enough. Keely Mayhew, can the prosecution use her other convictions against her? And I don't think so. I don't think they'll be allowed to do that. Mildred asking whether or not Lori Vallow Daybell watched the Sarah Boone trial. Apparently not. I guess they don't get court TV in prison. I guess that may be a real disadvantage, actually. Hey, Bethany, thank you so much for gifting 10 Lawyerly memberships. That's fantastic. We are having a great time. We are in the middle of a process. We're writing our very own true crime novel in our members group. So definitely turn on your ability to receive memberships. Our mods will put in the chat how you do that. And maybe you'll be one of the lucky ones YouTube chooses from Bethany's gift. Thank you, Bethany. Katie W., member for 12 months. That's fantastic. Says, thanks for never making me feel stupid. We're about learning here. You absolutely don't have to feel stupid. Thank you very much. I appreciate that, Katie. Thanks for being a member for 12 months. All right. So Katrina, if Lori changes her mind during trial, can she change to have an attorney represent her? I think the answer is probably going to be yes. And that's why she has these shadow attorneys right there. So they're fully briefed on everything about the case and they're with her every step of the way. So that's my guess, is that the judge would permit that. I think he would have some discretion around that, but I think he probably would. I think that's why he made sure they were present. Does the outcome of this trial change anything for Lori? Asked Jan Shore. Not really, Jan, in the sense that she's already serving life without parole. I saw a question earlier. So why are we doing this trial? Why even bother if she's already serving life without parole? How many lives is she going to get? So the answer is that there are still issues on appeal and there are matters of justice. So as far as the issues on appeal, that who knows, maybe the Idaho court overturns the case. Maybe she has to go for a new trial. Maybe they even say, who knows, that they suppress some of the evidence and she's in the end not convicted. Well, she still could be convicted in this case. But the second reason I think is that justice is deserved for all of the victims. So if Charles Vallow was murdered, he deserves justice. His family deserves justice, just as the justice was meted out in terms of the kids and Tammy Daybell. There's still a reason to do it, just in terms of where our society comes out on it, in terms of the actual justice in the case. Okay, looking for question marks at the beginning. That's how I'll spot you and know that you had a question. Verified vegan. Was your dad a lawyer? He was not. An engineer. Worked for IBM for zillion years. Worked on the space program, actually, the Apollo missions and some of the electronics and stuff behind that. Megan wants to know, when is the trial starting? Approximately April 1st. They were talking about how they were going to do the jury selection, but that's what he thought. It would be right in that range. Tots asking, why does she get advisory counsel? Daryl Brooks didn't get one. Is it based on state law? I don't know. I think it's pretty common to have advisory counsel. I think it's a good idea. I'm not totally sure that Daryl Brooks didn't get that. It may just be that he drove them away, that he said he didn't want them, that he refused to use them. I did think he had a lawyer kind of shadowing in the background. I'm not totally sure about that, though. It's a good question. All right, let's see. Question marks at the beginning. How far will she be able to go with witnesses like Kay? My heart breaks for them, says Jersey Red 13. And Jersey Red, you have a good point. It's going to be very difficult to control. It's going to be difficult to control Lori if she gets on the stand, and it's going to be difficult to control her in cross-examination of the witnesses. And you can bet the judge is very concerned about that. The prosecution is very concerned about that. And I don't know how they'll handle it. It will depend on how far she goes and how aggressive she is. We don't know the answer until we actually get into trial. So we will find that out to come. All right. Well, we will be live again Friday night at 7 p.m. Eastern. I look forward to seeing you then. Don't forget two things. First of all, be sure to vote. If you want to see the Lori Vallow Daybell trial or Karen Reed, put Lori Vallow Daybell or put Karen Reed in the comments if that's what you want me to cover. I'll be interested in your feedback. And then also, don't forget to look on YouTube under the Lawyer Lee channel. And I did a post there. And in the post, I asked, do you want to hear from my dad on his 90th birthday? I want to interview him, but I need your help to persuade him. He is not yet persuaded. So let me know if you would like to hear from him on his 90th birthday. What has he learned? What is the advice he could give us? All right. See you Friday, 7 p.m. Eastern.